So I think this is, since last time I played Yankee Stadium, this is probably the widest audience I've ever spoken to, which creates problems. I got a little stiffness in the neck. So what I'm going to do is, I've got 4 parts to my speech, so I'm going to address the first part to the people over there. Now, when I look over there, I want you to sit up a little straighter, look me in the eye, and we'll maintain a little visual communication. And then the second part I will address to you all, the third part to you, the fourth part to you, and then the rest I'm going to talk to the cameraman. So, I want to talk first about the right to be forgotten. We spent a lot of time talking about this in 2014 when the European Court of Justice handed down the ruling in the Google, what's referred to now as the Google Spain case. An action had been brought before a data protection organization in Spain, which ruled that the individual who had brought the complaint, a man who probably was trying to get a little privacy into his life, but whose name is now on every website throughout the world, Senor Mario Casteja Gonzalez. Anyway, this brave individual stepped up to espouse the rights of individuals to have negative information, or perhaps I should qualify that as irrelevant negative information removed from the ability of people to find it on the web. Mr. Casteja had a property problem at one point a number of years ago, and there was a newspaper article which somehow was deemed so newsworthy that it was embedded in the web. And so if you searched his name, you came up with a story about his property problems. And he thought, you know, I dealt with that years ago, it really shouldn't be hanging on. So he asked the data protection organization in Spain to tell Google to take that information out, and they did. And it then went on appeal to the European Court of Justice, which confirmed or affirmed the data privacy ruling that under the EU directive on privacy, this was required, that the data agency needed to de-link or de-index this guy's name and this story so that it wouldn't appear the next time somebody went onto Google or whatever other website and tried to find out information about this guy. So naturally, when that happened, there were cheering in the streets by some and moping faces by others about the negative influence of this decision. This was going to prevent libraries from functioning in the future because they wouldn't be able to find any information about anybody or anything. Well, that kind of extreme concerns doesn't really seem to materialize, but the same expressions of concern continue. The data I've seen is that Google has received 500,000 requests to remove information over the last 3 years, and has in fact complied with 43.2% of them. So that's not quite 250,000 bits of information that theoretically is no longer available. There's figure out how I can do this. Yeah, okay. So a couple of things that are trending right now is that the EU, which is where this particular right to be forgotten has really exploded into life, they have a new regulation that's going to come online in a year and a half, the General Data Protection Regulation, which continues, despite the hullabaloo about the right to be forgotten, which continues the same basic principles about the right to be forgotten, and allow EU citizens to request that information about them, negative information that is no longer deemed newsworthy or appropriate can be removed. The International Federation of Library Associations, IFLA, is a strong voice urging restraint with respect to the right to be forgotten, saying, well, we're really got to balance these things. Yes, individuals have some privacy rights. On the other hand, everybody else in the world has a right to know what's gone on in the past, and we don't want to eliminate the ability of people to do research and to find out what's been going on historically. They're focused right now, as are a number of others, on a case that is now before the French High Court, the Conseil d'État, which has been asked to rule on a French Data Privacy Commission ruling that says not only in France, but everywhere that Google does business, if there's a takedown order, then they have to apply that everywhere in the world, which would include the United States. Google, not surprisingly, is a little put out about this. So they are fighting this as hard as they can before the French High Court. So that'll be an interesting one to see. One of the quotable bites that I saw from one librarian talking about the effect on the U.S., they said that the odds of the U.S. adopting a right to be forgotten are close to zero. I'm not so sure that that's true. There are certainly some existing rules that do allow certain kinds of information to be removed from the public record, so to speak. But it's not as strong a legislative base to build on as in Europe. So this is an area to keep in mind, or as we say, not forget. Oh, wrong button, sorry. There we go. Okay, so turning from the right to be forgotten to the right to access for individuals with disabilities. A couple of months ago, the University of California at Berkeley received a letter from the Department of Justice announcing that they had found that Berkeley was in violation of the Americans with, oh, I'm sorry. So sorry, sit up. Okay, your turn. There will be questions later. So Berkeley got this letter from the Department of Justice which said that you're in violation of the Americans with Disability Acts, Title II thereof, for failing to give proper access to the handicapped, particularly those with visual and audio problems, to their online open access courses. You could go on YouTube, you could go on iTunes, and you could go through the internet and get a MOOC, a massive open online course, right? MOOC? Yep, okay. And you never outgrow your need for MOOC. So the university was in all good faith and thinking that they were doing the great and noble thing, making all of their courses, not maybe all, but many of their courses available through digital recordings and things through YouTube and the internet. And the government said, well, you know, that's all well and good, but if you're blind, you can't take advantage of this. And if you can't hear, well, you can't take advantage of listening to this. So we're going to order you to change all these things so that they will be available to all citizens who have disabilities related to this. And the university's response was, you know, no good deed goes unpublished. So they said, well, you know, we're going to look into this, and but you know, our reaction right now is this is going to cost a fortune. And we have like no budget. I mean, one of the reasons that they were doing this for free was because they couldn't get money for doing this. It wasn't commercially viable, so they weren't able to make money the way they could from giving people a degree and whatever they would take a degree in at the university. So there's no kind of money flowing through to pay for anything, and they justifiably felt we're not going to be able to take money that would otherwise have to go to degree-seeking students in order to run these free programs. So we're going to have to figure out how we can do this, if at all, and whether the government is going to be at all flexible in this and work with us. So right now, we're still in an unknown state, but the great fear is that this will put an end to all the kind of free programming that Berkeley was making available, and by inference, by analogy, to any university anywhere that opens its course catalogs up to this kind of free education without making it available to all, those who can't see, those who can't hear. Those are certainly justifiable and worthy ends, but trying to balance all this is not an easy thing. So that's something to watch as well. So let me now turn to the Georgia State case. We've talked about this a couple of times in the past, and I've statused you on it. Let's see, you. Okay, everybody's here. This is your turn now. So Georgia State is not unusual, I would say, in having a program where professors can specify the readings that students must do for the classes and to put the materials on reserve. Now, it used to be that the teacher would say, okay, you got to read 20 pages from the Smith and Jones book, and we're going to put that at the library, and you go down to the library and you can check it out for 2 hours, fall asleep, and then bring it back, and then realize, oh, I didn't read the book. So in order to make this whole process easier, as it's been recognized, technology has moved along, they have electronic reserves. So they can copy a book or a portion of a book and turn it into a digital copy, which they can allow students to access online for their readings. Or they make electronic course packets. Now, lots of schools for years have done hard copy course packets where the teacher would say, okay, I want 10 pages from this book, 20 pages from this one, 100 pages from that one, blah, blah, blah. It all gets photocopied and bound into a course packet book, which you can go and buy at the university bookstore. And for those many times, the Copyright Clearance Center or some other mechanism is used by the university or the professors to get permission to publish those in hard copy. Well, there's mechanisms to do this electronically as well, but somehow it's become viewed by the university, some universities and some professors, as too much trouble to do this, to get these permissions, and it costs money, and isn't it just better if we just photocopy the stuff and scan it and digitize it and make it available, and then we can cut out the whole middleman called the publisher. So this, not surprisingly, has caused a negative reaction among publishers, and that has become visible in lawsuits like the Georgia State case, where in 2011, the group of publishers brought suit against the university and named like the Board of Regents and the president and everybody else from Georgia State as parties in this copyright infringement. because they said that there were 6,700 works that were being photocopied in part or in whole and used in some 600 courses. So this was massive copyright infringement from the publisher's point of view. So the case goes to trial, and it all got weird when it got into court, as so often is the case. And it ended up that the case was all about like 100 books and 100 examples of copying. And what the court ended up doing, the trial court, was sort of establishing some rules of thumb, being a little overwhelmed by the volume here. Was quite grateful that it was only down to 99 and not 6,700 books, and imposed some kind of rules of thumb, which was a principal one being that if less than 10% or no more than one chapter of a book was used, then it was fair use. And the case goes on appeal. The publishers thought, well, we don't really like that rule. In fact, we don't like the way the court did this at all. So we're going to take this whole thing up on appeal. They took it to the 11th Circuit Court of Appeals in Atlanta. And the 11th Circuit, somewhat ponderously, went through in 2014, reversed the trial court, really on a theory that, well, the trial court really didn't exactly do the fair use analysis correctly, so we're going to send it back. But didn't really chastise the court for a number of its theories. That, well, this 10% or one chapter rule, that's kind of mechanistic. I mean, maybe that would be okay in particular cases, but we're going to send it back for the court to look at again. And so that was 2014. In March of this year, the case came back from the district court, and basically the court duplicated its prior opinion. It copied itself, which I guess wasn't really a copyright violation of its own opinion, but they said, well, okay, I'm going to think about it, and so we're going to think about each of these things, and we're going to balance it the way, and I'm balancing in my mind each of these things the way the Court of Appeals said, but they came out to basically the same ruling, and there was like 4 instances where there was too much taken. It was more than 10%, it was more than a chapter, and in those situations that was a copyright violation. But because the other 95 instances were fair use, the district court said, well, the university has won and we're going to award like $2.5 million worth of legal fees to the university for having to go to the trouble of defending itself against these accusations. Will that case get taken up on appeal to the 11th Circuit? I would certainly think so. So we haven't heard the end of it. It's the 2-year locust. It comes back every 2 years for a report here. But it's obviously an issue of enormous significance, because from the publisher's point of view, they say, wait a minute, how can this be happening? This is like a child talking when these courts look at this stuff. We're in the business of getting writers to publish things or to present things to us. We publish them, and the whole system works with this thing called money, where we pay, not much, but we pay authors, and then we get money, not much, and we get money, and that so we give some of that to the authors, and then we spend some on the printing, and and in the end, we line our pockets with pennies. So the whole process collapses. It falls down if anyone, particularly those that are our target audience. I mean, these are books for academics and academic uses, and if nobody has to pay for this because they don't want the whole book, they just want to take half of it or a quarter of it or 10% of it, how are we going to make any money? How's this whole thing going to work? So the publishers generally think that they're not being heard. The ecosystem, as they say, is being undercut. So there are some similar cases that are going on in other and other places in the United States and abroad. And in particular, for example, just a month or so ago in Delhi, India, and someone will need to remind me, I can't remember the difference between Delhi and New Delhi. I think they're two different places, but maybe they're connected. At any rate, they're near each other, right? So in any event, Delhi University had this arrangement with a photocopy shop. And they said, okay, we're going to channel you all these books, and you photocopy them and put them into course packets. Now, in the United States, even under the 11th Circuit ruling and under the district court ruling, it's almost sure that that would be a copyright violation if a photocopy shop made physical copies. Somehow, magically, it's not transformative, but it's different if it's electronic. But if you're making paper copies and it's a photocopy shop and you're doing it for commercial purposes, that would be, oh, I'm sorry, this is now your group. This would be a problem in the United States for the photocopy shop, because they're charging money to make copies and deliver them to students. But that nuance didn't really seem to appeal to the court. This is a trial court in Delhi, and the court said that no, this is actually all for non-profit purposes. It's for students, and students don't have a lot of money, and and then the publishers have a lot of money, and so the students shouldn't have to pay for the books. And in this case, they were actually, in some cases, like photocopying the whole book. So the fair use doctrine, which actually is embedded in Indian copyright law, just like it is in the United States, of course, says fair use is if it's a university and it's for students studying, you can copy the whole thing, and you can do it in hard copy, you can do it electronically, you can do it whatever way you want to. But it's fair use because it's for this public purpose, for this nonprofit educational purpose. That's a kind of extreme interpretation, excuse me, of this kind of rule that there is this educational exemption in U.S. law and things, but going too far like this is, as we say, going too far. So we're going to see whether this is on appeal. I got a hold of a friend of mine who's a lawyer in India, and I said, "This is going to be appealed," and he says, oh yes, this judge is reversed all the time. I don't know whether it's on copyright cases or on what, but anyway, he seemed quite confident it was going to get reversed, which may be comforting to the publishers who are involved. But in any event, it's a fascinating fight that's going on right now, and you can see both sides to it. But it does seem, you take a step back and you say, wait a minute, copying hundreds and hundreds and hundreds of books, that's okay? Well, of course, we had the whole thing with Google Books, and we had the whole thing with HathiTrust, and oh, well, that's okay over there, but maybe it's not okay over there. So anyway, this gives us something to talk about every year. Last, I move on now for my annual song for you all. And this is going to be a little different. You're all going to actually have to help me here because this is going to be a rap song, or maybe it's a hip hop. I don't know the difference between hip hop and rap. So we got to go. Here we go. Here's a little story that I got to tell about three publishers that done went through hell. They started off pursuing old Georgia State, hoping they would win before a magistrate. They said the college has been acting criminally by making packets that are looking too similarly. Instead of buying books or paying for our rights, they're ripping off the bread from our boys who write. Hang on now. Keep going. The school says, hey, you're always just being fair, using up some words a chapter here and there. The judge says, yeah, I dig from where you came, 'cause you are in the non-profit education game. You didn't use too much of what those authors say, and them publishers are losing too much anyway. So put it on reserve on a hard drive or a floppy. You are good to go to take the books and copy. Now we go for the big finish here. Whoa, who? You copying me? You copying me? Whoa, who? You copying me? You copying me. Thank you, thank you. My performance will be available on iTunes.